All right, welcome everyone to today's webinar titled Navigating the Path to Incorporation, a Guide to Incorporating Your Business in Bermuda. We are excited to have with us a panel who will provide insights and practical advice on the benefits of incorporating a business and then the processes that are involved. Join us today, we have Janice Gutteridge, Director of Corporate and Commercial Department at Cox Hallett Wilkinson, George Outerbridge, Supervisor of Registration at the Registrar of Companies, and then we have Kalyn Outerbridge of Uplift CBD Dispensary, just to kind of give some insight on why she decided to incorporate her small business. So their backgrounds and extensive experience will provide valuable insights and hope you guys learn a lot by the end of it. So we'll kick it off with a presentation from Janice. Let me just give Janice access.
Good afternoon, everyone. Hopefully you can see the screen with the presentation attached. I did send a copy through to the BEDC, so if anyone wants it, feel free to release it to whoever requests it. So I'm concentrating on understanding the need for incorporation. So the question is, why opt for limited liability? And in fact, what is limited liability? Limited liability takes the assets and the debts of the company, which are owned by a separate legal person, which is the company, as if it were an individual under law. And that entity owns the assets and incurs its own debts in its own name. And the concept of limited liability is that the assets and debts of the company are ring-fenced or separated from those personal debts. So the debts of an incorporated company cannot be enforced against an individual unless there is some form of guarantee, a legal guarantee, which says that the individual has secured those debts or assets of the company. So that's what we refer to as limited liability or ring fencing. So again, the personal assets of the individual are separated out from the assets of the business. So that would be, residential property, personal bank accounts, stocks, anything is protected from the risk that is inherent in incorporating a startup. The company is permitted to raise capital through the sale of shares in order to finance its operations. It can take out debt from a bank in order to finance its operations, and all in its own name. The incorporating makes it easier to obtain lending facilities from the banks because they can secure the assets of the company and the shares of the company as security for those loans. And typically, if you are an incorporated limited liability structure, it is easier if you're looking to exit the company, it is easier to sell the limited liability structure that is in place rather than have to sell off each asset owned by the company. So for instance, if you're a plumbing company and you have trucks and you have plumbing equipment, that employees, that sort of thing, an asset sale would have to deal with each specific asset individually, and you would have to provide certain warranties and reps about each asset. Whereas if you are looking to sell a company, it is a share sale, so it is a much more simplified process to exit. Sorry. So the question is, who regulates incorporated companies? And that is done by two entities, the Bermuda Monetary Authority, which regulates Bermuda's financial service sectors and vets ultimate beneficial ownership, and the Registrar of Companies, which tracks, processes, and administers all limited liability companies and LLC companies, both local and exempted. I'm not going to go into too much detail about the Registrar of Companies because George from the ROC is presenting next, and he can speak better to those topics than myself. There are several types of avenues in which you can start a business. You have your sole proprietor, in which the individual starts the company in their own name without limited liability, and the company is known by that person's name, trading as XYZ business. You have the general partnership, which again does not have limited liability, but is 2 or more persons working in partnership in order to run and administer the business. You have the company limited by shares. In certain circumstances, you may look at a company limited by guarantee, which is most frequently used in the circumstances where it's a charitable entity that is looking to be run. And then you have the limited liability company, or the LLC. For the sole proprietor, there's no formal requirements required to start the business. The owner is personally liable for the debts of the business, and there's no separation between the owner's finances and the company's finances. So in that sense, there's no ring fencing or no limited liability. The business does not have to pay any annual filing fees, although it will have to register for things like payroll tax and social insurance. For the general partnership, the liability is not limited. Each partner is liable for the debt obligations. Each of the partners have the ability to bind the partnership, which means to execute agreements, deeds, enter into contracts, that sort of thing. There's no legal requirement to register a local general partnership, so there's no initial or annual filing fees. A partnership agreement can be written or oral, and that agreement governs the relationship between the partners. The partnership may elect to have separate legal personality, but it does not have to. For the LLC company, the limited liability company, the legislation was introduced in 2016 and became effective at the start of 2017. This is really a hybrid or a mixture of the limited liability companies and the partnership. The members are not liable for the debts and obligations of the business. They are purely liable for their membership interest, which is the amount that they have agreed to pay into the LLC. The members of the LLC may also act as the manager and operate the business, and the LLC is governed by the limited liability company agreement. The LLC company, how does it compare to a company limited by shares? So it can be faster to form a standard form of the LLC because there's no advertisement requirement, which there is for companies limited by shares, in which you have to advertise the beneficial owner and shareholder of the company. More complex LLC structures will require more advice prior to formation, but generally a standard LLC, which is run by 1 to 2 people, where it has one manager being appointed to manage the affairs of the company, will have a fairly standard form of LLC agreement. So you're looking probably about 7 to 10 days. The costs for the formation of an LLC are slightly more expensive due to the drafting requirements of the limited liability agreement, and the annual government fees are slightly higher than that of a standard company limited by shares. The LLC is not as formal as a company limited by shares in that it does not have to have the annual general meetings, which the company limited by shares does, but it still requires the managers or the members, in the absence of the managers, to approve the actions of the LLC by written resolution. The LLC provides for more flexibility. It basically allows for the members to agree the actions of the LLC by way of agreement. So long as everything is contained within your LLC agreement, then you can agree, whereas the companies limited by shares are governed by the Companies Act 1981 and by the bylaws, which set out the formal requirements for instance, how you can transfer shares, how you can hold a meeting, that sort of thing. Which one is preferable? Which form, a limited company by shares or an LLC? That depends on where you're located in the world. The US is more familiar with the LLC. For instance, you have a lot of Delaware or Wyoming LLCs that are in existence in the States. For example, Apple. The rest of the world, there's no real preference. In Bermuda, it's more familiar to use a company limited by shares because that was the standard go-to form until 2017. So for the company requirements, a company limited by shares. In order to set up a company limited by shares, you have to have your constitutional documents, which is your memorandum of association and your bylaws. Once you have your memorandum drafted and signed, you can file this with the Registrar of Companies, who will produce a certificate of incorporation. The company that exists from the date of the certificate of incorporation, and it will have to have a series of initial meetings in order to formally organize the company. It is the directors of the company that manage the day-to-day affairs of the company. The shareholders are the investors of the company. So they invest the capital and then they appoint the directors to manage the affairs. A shareholder may also be a director, but they don't have to be the same individuals. So what are the statutory requirements of a company limited by shares post-incorporation? You have to file a list of the directors with the Registrar of Companies and submit the filing fee, which is currently $95. You have to register an extract of the company bylaws. You have to register details of the individual beneficial owners controlling 10% or more of the voting rights of the company. And if there are any changes to beneficial ownership, you have to make those filings within 30 days. You have to maintain proper books of accounts, which basically show the assets and the liabilities of the company or monies coming in and out. And you would have to hold an annual general meeting of members in each calendar year, unless the directors and members of the company have elected to dispense with the holding of the annual general meeting. The statutory requirements for partnership and limited liability companies post-formation. You are required to file details of all individual owners controlling 10% or more of the voting rights of the corporate entity, and you are required to maintain proper books of account, again showing the assets and liabilities or the incoming and outgoing monies incurred by the company. You are also required to maintain a set of records for each entity. For the LLC, that would show the register of members and the register of managers. And for a company limited by shares, it is the register of members or shareholders and the directors and officers of the company. A company limited by shares is required to have a secretary, and both are required to have a registered office, which is a street address, i.e. Your residence, or a licensed CSP office, which acts as registered office of the company. You cannot use a PO box. And I think that is about it for my presentation. If there are any questions.
There are some questions, but we'll just do some Q&A at the end. Okay. So I do see some questions coming in. So if any of you who are watching have any questions, feel free to add them in the chat box and we'll get to them at the end of the presentation. So thank you very much, Janice. So next up, we have George Outerbridge from the Registrar of Companies.
Good afternoon, all. Janice, thank you very much. That was a very good presentation, given a lot of information. I'm just going to expand on a few things that Janice mentioned. So the Registrar of Companies is the, we are basically the birth straight through to the death of entities. So we deal with everything from registration, initial registration, to company maintenance, as well as the dissolution or striking off of entities, removing them from the register. And we're also responsible for all corporate regulation as far as entities go. And we're responsible for, we're actually responsible for the beneficial ownership of entities. That's as far as regulation, which the BMA currently holds for us. Now, in my presentation, I'm just going to go through the actual process for actually incorporating a company. So I just wanted to confirm that screen showing. Yep. So the Registrar of Companies has a fully online digital register. This is where you would actually go to actually submit applications, submitting applications for registration, and all maintenance services as well. In my presentation, I'm actually going to go through a couple of I'm going to include some forms. Those forms are included down here under the Registrar of Companies information forms links. And then also we have instructional videos on doing the forms and the legislation that is applicable towards different entities. Now, in order to register an entity, you must first be a logged in and registered user. I'm not actually going to go through that process today, just to keep it short. But that is covered in the videos that are provided under instructional videos. I'm going to hop right into it. So once you're actually on here, the first thing you have to do for every entity is to reserve the name with the Registrar of Companies. That would be under Register Services and reserve an entity name. I'm not going to go through that part right now, but those videos are provided for that. After you register a company name, the next step will be to actually provide an advertisement. The Companies Act requires that every local company advertise prior to incorporation, stating the names of the people that's opening the company, the name of the company, and once that is posted, then an application is sent to the BMA with the beneficial ownership information. Once the BMA gives them no objection, then you would actually come into our portal to actually register the company. I'm going to go through registering a company limited by shares, and it'll be just like this. You'll go to services, register services, companies, and register a company limited by shares. Now, once you reach this stage, you would have to enter a bunch of information, such as the type of company. In this case, we're going to go with local. You'll select the name that you registered. If the entity has a secondary name, now secondary name in accordance with the Companies Act is only whatever the legal name is, all in another language. So basically, if you had the name registered as a secondary name in Chinese characters, most local companies don't do that, but I just wanted to give a quick explanation on that. If the company is incorporated under a private act, that's a separate process. In most cases, they will not be. Now, this was the extract of the bylaws that Janice referred to. So inside of here, that refers to section 13(2), A, E, and F. There's a specific sections of the bylaws that an entity has that would have to be registered with us, and only those 3 sections are here. That is not required at incorporation, but this allows you to ensure that your company is in compliance prior to after incorporation. So if you do not file them now, you have 30 days to file these. Return of shareholdings is also the same. You have 30 days to actually file a return of shareholdings. That just indicates the amount of shares that you have, and the ownership of them. That you have to put in what the proposed financial year-end date of the company. Select out a business activity category. And then the actual business activity description. Now, as I said, the Registrar of Companies is the regulator for corporate entities, and this also covers economic substance. So you would have, if the company is performing a relevant activity in accordance with the Economic Substance Act, you would have to indicate that here, or that is not. If the entity has a limited duration, so if the entity is proposed to dissolve at a future date, you will put that in here. You also put in the date of the approval, the consent from the BMA. That's what I mentioned earlier, and they will provide that. And you would actually upload the consent from the BMA into there. Now, for this is the address details. So every entity is required to have a registered office in Bermuda. That's why you cannot actually change this. You can't change the company on it. It is actually, it has to be in Bermuda. It has to be a street address. And I just want to elaborate on the registered office for a little bit, because there are obligations that the registered office has to maintain in accordance with the Companies Act. And this includes being open to interested parties to actually view documents between the hours of 9 to 5. So this, as Janice was saying, some people actually put the registered office at their house. Just people need to be aware of that they need to be, that the register of members and other documents need to be available for people to actually show up at your house to view them, if you choose to have the registered office at your house. The register of members can be held at a branch register, but if you do wish to have it at the branch register, you will select no and add in the branch register. Alternatively, you can just leave it at yes, and also you can add a physical address for the entity. Now, the objects and provisions of the Companies Act. The Companies Act actually puts in what the objects, what objects and provisions, what objects are available. If the objects are not part of the restricted objects, then you would select yes for here. If no, you would actually have an option to enter in the objects. Now, what this basically means is, if you select yes for the unrestricted, the company can do any object, any business activity that is not restricted. If you select no and put in a specific object here, for instance, if I put down that I am selling cars as my object, that is the only thing the company will be allowed to do. It will not be allowed to conduct other business activities. And then also you can enter in the provisions regarding the powers of the company, but that is optional. This is for the entering in directors. You can enter in directors at this stage if the director is known, but most people at Incorporation do not know the directors yet, so you do not have to put them in at this stage. Subscribers. Every company must have at least one subscriber. And for local companies, it is usually the owner of the company. You would have to indicate if they have Bermudian status, on the nationality, and also the number of shares that they are subscribing to. License details. Now this part is only, you do not have to fill out this part at incorporation, but for a local company under section 114B, you can apply for a license. Okay, let me start over. For a local company has to have more than 60% Bermudian ownership and directorship. If a company has less than 60%, you can apply for a license to carry on business, and that's what this section falls under. Also, under section 9 of the Companies Act, or section 4A, sorry, you can actually carry on restricted business activities, and those are listed out. So those are such things that are restricted are medical practitioners, so doctors, lawyers, any of the accountants, any of those sort of fields are actually restricted. So you would actually have to apply for a license to carry out those business activities. Also, if the company is going to require is going to be holding land, an application will have to be submitted for that. So for the share capital, now this is, like I said, this is a company limited by shares. So you would have to put in the amount of share capital that the company is to be starting with. You can also, at this time, put in the amount of issued share capital. That will be the ones that are issued out to the subscriber. And share premium, if you, this is actually covered under section 42 of the Act. It does not usually apply to local companies, but that's covered more generally in there. You would have to fill out the details of classes of shares form. That form is found on our homepage. And also enter in the percentage of all issued shares beneficially owned by Bermudians and the percentage of voting rights which can be exercised by Bermudians. Segregated accounts. This is if you wish to apply for a segregated account company under the Segregated Account Companies Act. And then you would have to confirm these declarations, as well as upload the authorization document. That document can also be found on our page. Once everything is in, then you have the option to review all of the details that you provided. And press submit. Now, once you've actually got to that page, this is where you come in to pay all your fees prior to submission. So there's actually a $320 application fee to be registered, the registering of a memorandum of association, the filing of a return of shareholding fee, and the annual fee. So every local company has to, at the time of incorporation or within 30 days of incorporation, and on the 31st of March of each year, pay an annual fee. This annual fee is actually based upon the issued share capital of the company, and the fees are contained in the 5th schedule of the Companies Act. Now, there are multiple ways you can actually do transfers to the Registrar of Companies. Either you can have a debit account actually linked up to your user account, which will allow you to deposit money via wire transfers. Alternatively, you can use credit card payments to make payments to the Registrar of Companies. And once you hit continue, your application gets submitted for registration, which will be reviewed by one of the registration agents internally, and they'll provide you with, and once that's approved, you will receive your certificate of incorporation that has the company registration number, the date of incorporation, and the company is now in legal existence. Now, there was a few disclaimers that I wanted to put up as far as the Registrar of Companies, what we can provide and what we cannot. So the Registrar of Companies is here to assist with the processing of documents and the submission of applications. What I find is people call up to the Registrar of Companies with questions such as what type of company is best for me? What do I have to do? What do I have to do as an owner of a company? Those sorts of questions. We cannot provide anything that constitutes as legal advice. So we cannot advise on matters that you should be going to a lawyer for. In all those situations, you should be going to a lawyer for those for those type of questions. But like I said, what we can provide assistance with is the actual application process. All of our fees that we charge are contained either within the legislation or the government fees regulations. And but once your company is incorporated, there are lots of other maintenance applications that have to be done, and there are also obligations on the directors of a company and the registered office. So my best advice for anyone is, if you're looking to incorporate a company, make sure you understand the legislation that you're incorporating under, whether it be the Companies Act or the Limited Liability Companies Act. And then if you have any concerns or questions, then you should seek legal advice for this. With that, my side's done. Then we'll answer any questions at the end, and then hand it back to you, Deshaun.
Thank you very much, George. So yeah, if anybody has any questions while everyone is going through their presentations, feel free to add them. I do see that there are some questions in there, so thank you. Just show my screen. Just want to confirm if can everyone see my screen? Kailyn, can you see it?
Yes.
Okay. And is it going through the slides?
Yeah.
Okay, cool. So I'll kick it off to you.
Okay. Good afternoon, everyone. My name is Kailyn Canonaire. I'm one of the co-owners of Uplift. We are a CBD company here based in Bermuda on 1 Burnaby Street in Hamilton. We have various CBD products, and I'm just going to talk to you a bit about why we decided to get incorporated and what sort of things you should be noting when you are looking at getting incorporated. So we go to the first slide.
Did it go to the next slide?
Yeah.
Okay.
So it's not going to the next. Oh, there we go. Okay. Okay. Go back. Yeah. Okay, so a local company. So we decided to incorporate our company as a local company. Operating a business as a limited company means that you basically separate your finances as an individual or as a shareholder from the business finances. So you're taking away some of the liability personally and saying that, okay, and if anything goes wrong, they can only come for the business and the business assets. It limits the liability on the person, on the individual. This is particularly important if you have product-based businesses, because anything can go wrong. People may not like your product or may have an adverse effect to your product, and they may want to seek damages. And, you know, unfortunately, this is some of the things you just have to be prepare for in a product-based business. So I think that is a good thing to just to take into consideration when you're considering to incorporate whether or not you should as a product-based business. Some of the documents that you want to be aware of when you incorporate is your certificate of incorporation. That's basically like your passport or your legal identity of the company. Then your memorandum of association, that's your nature of business, or what does the company do. Many times you'll see memorandums of association that are very basic. They don't really go into much detail in the nature of business, and that it will probably say it has all the rights and powers of a natural or legal person. That's just so that it doesn't limit your business if you want to go into other things, other avenues of business. So it's standard wording in there. So that's the basic wording that you'll see, the powers of a legal person. And then your bylaws. The bylaws of the company is like a Bible. It's like your rules. What can the company do? So in the bylaws, it'll have things like the shareholders cannot, or the directors cannot make a decision without the shareholders' approval. Different things like that. So it's just that you know what sort of things can be done as according to your position and things like that within the company. And then your minutes and resolutions, those are what initially you would have to set up the company. That sets the intentions of the company. So if you're opening up a bank account at the same time you're incorporating, it will have that in your minutes or your resolutions. We resolve to do X, Y, Z. And then your director's acceptance letters. A lot of times people forget that you have to accept the positions that you allocate. So if you're having directors, you need to sign your acceptance letters because those are what appoints those officers to the company. And then the subscription, subscription is the document that the shareholders sign to subscribe to the shares. Next slide. So a local company is Bermudian majority. So that means the ownership has to be majority Bermudians. So this is sometimes known as the 60-40. So if you have foreign investors that want to have an ownership in your company, you need to make sure that you have the majority ownership if you're setting up a local company. The annual fees are reasonably priced, as you saw from George's presentation. So I think that's a good reason to get a local company set up. The directorship, again, has to be Bermudian majority. So when you're appointing officers or directors to run your company, keep that in mind. Another thing, as I mentioned earlier, it separates you from the business. And also, if you want to have investors in the future or operate as a business with dividends and shareholders, it's easy to transition into that. So that's another reason why I would say setting up or incorporating is a good idea. Another thing to worry about is your AML ATF requirements. Be prepared to provide certified copies of your ID and your utility bill to your CSP, whoever is going to be incorporating a company. Because that information does need to go to the BMA. So that's it. That's all the kind of tips I have. If you have any questions, put them in the chat. Thank you very much.
Thank you very much, Kailyn. So we will open up the questions now. So if Janice and George want to come back out. So one of the first questions was, is a limited company, so an LTD company, a general partnership, or is it a limited liability?
They're different entities altogether. So you can have a general partnership in which two or more persons declare that they're going to be working together to own and manage the affairs of the business. And that is one form of entity. Then you have your LTD, or your company limited by shares, which is another form of legal entity that gives you limited liability, and it has to have the either LTD or limited at the end of it. And then as a third form of entity, you have your LLC or your limited liability company. And so both the LTD and the LLC will give you the limited liability and give you that protection, that ring fencing of assets from personal assets, and the entity will be treated as a separate legal personality. It's just a matter of whether the cost and the characteristics of the entity suit your needs the best.
And just to expand upon what Janice just said, each one of those entity types has their own specific type of governing legislation. So and that can't be crossed. So you cannot refer to the Limited Liability Companies Act for limited companies, which are incorporated under the Companies Act. And also for partnerships, you go to the Partnership Act for anything to do with partnerships. Anything in the Companies Act does not apply to partnerships. So each one of those entities has their own specific legislation that governs all of that governs their whole processes.
Yeah, they might have similar requirements, but you do have to be familiar with the specific act so that you know that you're in compliance at all times.
Thank you.
And I'll just add, sometimes people get confused with limited and limited liability and LLCs. The nice way to remember is limited by shares is a limited company. It's not an LLC when most people refer to it as a limited liability. That's the avenue that most people go for. So limited by shares, limited liability company, or an LLC. It's different.
And somebody asked, so this might be both for Janice and George, might be a little bit combined, but what is the difference in price between an LLC, an LTD, or a company limited by shares? So I guess it kind of goes hand in hand between using a lawyer or CSP and then registering with ROC as well.
George,
Or
you
is
want
there
to
a
go
difference?
first on the ROC fees, and then I'll do the legal?
So with limited by shares, that is actually based upon the amount of share capital that is issued out. That's the amount that has been issued to people. So if someone comes in and you have shares that worth $1 per share, and somebody has 5,000 of them, that means that you have 5,000 in issued share capital. So the fee actually ranges. It starts at $685, and it ranges, I believe, all the way up to 15,000 for local companies. So depending on the amount of share capital that you've issued out, that is what you would be. For LLCs, for limited liability companies, there's a flat fee of $900 per year. That's the annual.
So, and then if you are engaging a CSP or a firm to help assist with the incorporation, including the disbursements that we pay out to the BMA and the ROC, average cost for a company limited by shares are a little bit over $3,500, and for an LLC, they are about $3,750 to $4,000, depending on the complexity of the agreement that has to be drafted. You'll find that the company limited by shares, there are more forms of precedent that we can use, which cut down on the tailor drafting. So we spend less time doing that original drafting, where for a LLC, we have to reflect the commercial agreement between the members, or for the single member. So we have to sit down and talk to them and then tailor each agreement according to what the needs for that person are.
And I guess to kind of piggyback on that, we have a couple questions on, can you register without a lawyer or without a CSP, or is this something that I could do by myself?
There are no restrictions as far as a local person coming in and registering. The only thing is, like I said, there's the Registrar of Companies, as I said, we're actually responsible for compliance of entities. So actually right now at this current point in time, my actual compliance team is actually out doing site visits at registered offices right now. So although you can register, you have to make sure that you have everything in accordance with the Companies Act, because there are hefty fines if you're not. And if our compliance unit comes out and you do not have all your ducks in order, then the fines can sometimes outweigh the cost benefits. So that's my only caveat there.
And as some of our clients are kind of micro and small business owners, and some medium-sized businesses, you know, they always think about cost. But when do you think, I guess between Janice and George as well, when do you think that a business is ready or should kind of be ready to incorporate? Like at what stage, or is it the type of business that they're in? What's your suggestion?
The best answer is as soon as you can. If you can do it right at the outset, if you can have the money to incorporate, because that gives you the protection, whether you're in a product-based business or a service-based business, that any potential claims or some of the online ones, I know that there have been issues where, you know, they've had credit card fraud and whatnot, and the fact that they were incorporated really protected the individuals behind the business from incurring those debts on a personal level. The reality is that as soon as you can afford to do it is the answer. And it really depends on the risk nature of your company. So for instance, if you're going to be starting a restaurant, which is a high risk venture, you want to incorporate at the beginning, because, you know, restaurants are very risky and they're easy to fail. You know, if you have been working for a maintenance construction company and, you know, you're a skilled mason and you've been doing it and you are slowly starting to build your own business as a sole proprietorship, then you probably have the time to take up your money based on the nature of jobs that you're undertaking, right? Whereas if you're going to build the whole house, you probably want to be incorporated for that. But if you're going to be doing like building of walls or smaller limited jobs, then that's probably less risky. So you really have to consider, what is the risk here? What is the likelihood that something goes wrong? And at what point do I want to ensure that I have that protection in place?
And someone, I guess, as you were talking, says, as a newly forming company awaiting government approvals, is it advisable to wait until you have full government approvals before incorporating?
That's a very
loaded
general question. Yeah, because government approvals could mean anything: immigration approvals, planning approvals. You know what I mean? So there's a lot of different government approvals that you would need in lots of different situations. So,
but having awaiting government approval shouldn't really have a.
Yeah, that shouldn't really.
Well, it depends, because if you're waiting permission to do a restricted business, it is very important that you wait until you have that permission, that consent in place, because otherwise you're committing an offense if you're conducting a restricted business without the proper consents. So as George says, it very much depends what type of government approval are you looking at here.
Okay. Someone said, yes, it is a semi-restricted business. So I guess kind of wait for those approvals.
Yeah, I would wait for those approvals, yeah.
Okay. And this one, it says directed towards George, but I know ROC is not really supposed to give legal advice, but it says, what are the benefits to having objects restricted, or is it something dependent on the MOA bylaws and whether or not it is a regulated activity?
I can't really speak about the benefits. I can basically give you the distinguishing between them. So there are specific objects, whereas and this is with international business. If you're performing objects overseas, they basically lock you into a specific field. Also, with companies limited by guarantee, their objects actually have to state that they're only performing for charitable purposes, and they can't go out and start a for-profit business on the side. So it's not really I can't really speak to the benefits or the whatnot. Janice, you might be able to.
I can. So prior to 2006, there used to be a schedule of common objects that companies conducted that people used to go through and select. So your memorandum would end up being 3 or 4 pages long because you had this schedule that covered the most common types of business objects under, and that could range from shipping to mining to regular retail stores. And then if you wanted to keep your company but your business focus changed, you had to go through the formal requirements of applying and advertising the changes to the powers. And it was time consuming and it didn't leave much flexibility, and where there were big deals on the table, it caused timing issues. So that's how they came up with the concept of unrestricted objects, which were designed to give you a little bit more flexibility and allow you to make a shift in business, large or small, without having to go through and get formal consent of the Registrar of Companies, without having to advertise it in the papers, that sort of thing. So for most standard businesses, you will find that the advice or the option to ensure that you have unrestricted objects increases the flexibility that you have as a business owner and for the directors as the day-to-day administrators of the business. In certain circumstances, you need to make sure that you have certain additional objects or you have certain objects in there. That may be because the lender requires them. That may be because you want to make sure that you have certain landholding powers or other things that are in there. So that is the instance where you would perhaps look at having something in addition to or in place of the unrestricted objects.
All right. So I see we might have time for one more question. So someone asked, if you have an online business, what is it that the ROC compliance is checking for when doing site visits? And or are site visits required for an online business? And are there any difference in fees or processes for an online business?
So I think you have to differentiate here between the company and the business, because even though the business may be an online business, the company has to comply with the requirements of the Companies Act. So you have to have the registered office, you have to make sure your bylaw extracts are filed, that your directors list is filed, that you're maintaining the books and accounts, that you're maintaining the share register and the directors and officers register. So you really have to be familiar with the legislation that requires the company and differentiate between the business, because the ROC really doesn't look at the details of the business. It looks at the company.
Okay. Well, thank you very much. I will say, as we're getting closer to 1:30, if any of you who are watching are interested in incorporating, please reach out to Janice at Cox Hallett Wilkinson. She'll be able to better guide you through the process. And I will also say that BDC does have quite a few documents on our website in regarding to business structures, various costs and everything like that. And then George, will you say Janice is the first step before ROC, or?
Well, like I said, we can provide advice for application process, but we would always push people to get legal representation to make sure they don't get caught out for anything that they're not aware of, or they're not familiar with. So okay. It's always advised to go to a CSP if you are looking to incorporate, or to a CSP or a lawyer for any legal advice, and then to come to us for any additional information as far as registrations and such.
All right, Janice, any last words before we leave?
No, just if there are any questions, you can contact me or my colleague Eve. And that includes if you have any questions post-incorporation, because as George says, the ROC is there from the birth to the death of the company, and we're there to advise from the lead up to the birth or the conception to the death. So don't hesitate to reach out.
Right. Thank you everyone for joining us. I will let you know that the webinar is being recorded and will be on BDC's YouTube page afterwards. And I will also be sending out Janice's presentation and any information that George has given from the ROC to make sure that you guys have that information, their email addresses and everything. But thank you, Janice. Thank you, George. And thank you, Kailyn. I think you're still here for joining us. Have a great rest of your day, guys.
Thank you.
Thank you.